Hello and welcome to episode 71 of Not Reserving Judgment, a podcast about the latest intrigues, triumphs, and outrages in Canadian constitutional law. I'm Josh Dehaas, counsel with the CCF.
And I'm Christine Van Geyn, the CCF's litigation director. Joanna is away this week. In today's episode, I'm going to give you an update on a number of court cases that we are currently working on at the CCF.
And we'll share our bad legal takes of the week, where we take a lighthearted look at some legal opinions that didn't quite land. But first, I'm going to wade into a controversial subject that's on the minds of a lot of Canadians right now, and that's whether Alberta can secede and join the United States. Before people call me a traitor, I just want to clarify that this is not an endorsement of Wexit. This is just a thought exercise, since a lot of people on X and also in real life at an event I was at the other night seem to be talking about this. And basically the idea is that Albertans are, sick of being mistreated in Canada, and a lot of them would love to have the benefits of living in like a more prosperous, freer country, one that actually lets them build pipelines and doesn't take all of their wealth away from them. Frankly, as an Ontarian, it's a scary prospect. I wouldn't want to live in a country without Alberta, but I can see where they're coming from to some degree. So, on the question of whether they can secede, the answer is yes, but not unilaterally. So it's a little bit complicated. And we know this because in 1995, after Quebec, barely voted to stay in Canada, the Chrétien government asked the Supreme Court on a reference whether, under the Constitution, the government of Quebec or the National Assembly can affect the secession of Quebec from Canada unilaterally, and also whether that would be legal under international law. And at the time, I think people had assumed that the answer was no, and that's technically correct, since a referendum wouldn't automatically mean separation. So, they can't do it unilaterally, but that doesn't mean a yes vote wouldn't probably lead to separation, because the court says it would trigger this legal requirement to negotiate. And so I'm going to walk through that decision, but first I'm going to give you a history lesson, so get ready for it. This will all sound oddly familiar in 2025. So back in 1864, the US had just fought this monumental election with Abraham Lincoln, a moderate Republican, back in the White House, and the country was, almost tearing itself apart with the Civil War. And Lincoln and his Secretary of State had a policy to annex what is now Canada. And they had like a 1 million-man army raised for the Civil War that could probably take Canada pretty quickly if Britain wasn't willing to come and rescue us. And the policy was called Manifest Destiny. It said that, basically it's just a matter of time before the US takes over all of North America, as they already had done with the Spanish territories and the French territories, which they had purchased in the Louisiana Purchase. So anyway, perhaps to encourage annexation a little bit more, the US had backed out of its reciprocity treaty, which was, basically free trade of a lot of raw materials in British North America with the United States. And this treaty was like extremely important to British North America, just like the USMCA or the former NAFTA agreement is today, because basically everything we sold went southward to the US, which had a much bigger market and could like create finished products, which we could then buy back. So the government in what is now Ontario, then Canada West, both the government and the opposition joined together and met with Quebec, which was also on board, and said, we need to do something about this. And so they invited themselves to a conference where the maritime provinces were debating whether they should form a union. And John A. Macdonald proposed that, all the provinces should get together, not just the maritime ones, including the extremely far away Vancouver Island colony, and that they could build a transcontinental railway that would allow for free trade between the Maritimes, what is now Ontario, Quebec, and British Columbia. And this would, create this big market that would give them at least a chance of surviving in the face of US tariffs. And in spite of all their big cultural differences, Ontario was Protestant, Quebec was Francophone Catholic, The Maritimes was the Maritimes. They decided they were better off together, and so they united in with a constitution similar in principle to the UK's, and they created this division of powers, which is the Constitution Act 1867, that allowed for this new economic union known as the Dominion of Canada, while still respecting the diversity of the provinces. PEI and Newfoundland were not initially on board. PEI came on board in 1873. British Columbia came on board in 1871 to get the railway. But this remained extremely controversial, and particularly so in Nova Scotia because it was very wealthy at the time thanks to its port. And so the court notes in the Quebec secession reference that there was this early attempt to secede. And at that point, it was Nova Scotia. Kind of hard to imagine now that they would be the ones who want to secede, but that's what happened. And in this very first election in September 1867, Nova Scotia's Anti-Confederation Party won 18 of 19 federal seats. And the provincial election held at the same time also saw 36 out of 38 seats, so almost all seats, supporting the party that wanted to secede from the new union. And the Premier of Nova Scotia went to London and they said, no, too bad, you signed on to Confederation and you're stuck with it now. And then the court explains that, what emerges from this history and other history are certain unwritten constitutional principles. And these are what the court says are like the architecture of the Constitution. I don't think that's quite the right word, but what they mean is basically they're, principles that are like the beams in your house or the cement holding up your house, the foundation of your house. You can't necessarily see those parts of the Constitution. They're not in the text, but they're there and they're extremely important to the whole house standing. And the ones relevant here, according to the court, were federalism, democracy, constitutionalism / the rule of law, and respect for minorities. And what the court says is that when we apply these principles, it leads to the conclusion that to secede would be a constitutional amendment, and that would require negotiations. And the court says that because the question they were asked was whether Quebec can unilaterally secede, the answer is no, but that's because it would require negotiations with the other provinces and the federal government. And the court says, quote, the democratic principle would demand that considerable weight be given to a clear expression by the people of Quebec or their will to secede from Canada, even though a referendum in itself without more has no direct legal effect and could not bring about unilateral secession. But then the court says this negotiation is not optional. So they say the principles of democracy require that the other provinces in Canada negotiate, even if they don't eventually give in. And on the other question, like the international law question, I won't spend much time on that because international law isn't real, but they say it doesn't allow secession in this case anyway. So the court concludes with this. They say, the Constitution is not a straitjacket. Even a brief review of our constitutional history demonstrates periods of momentous and dramatic change. Our democratic institutions necessarily accommodate a continuous process of discussion and evolution, which is reflected in the constitutional right of each participant in the Federation to initiate constitutional change. This right implies a reciprocal duty on the other participants to engage in discussions to address any legitimate initiative to change the constitutional order. And while it is true that some attempts at constitutional amendment in recent years have faltered, a clear majority of vote in Quebec on a clear question in favor of secession would confer democratic legitimacy on the secession initiative, which all of the other participants in Confederation would have to recognize. So, there's lots of similarities here to the Quebec secession reference. The US seems to be using economic pressure to suggest Alberta maybe should get out of its abusive relationship with the rest of Canada and get a new red, white, and blue partner. But to get there, Alberta would first need to hold a referendum with a clear question. And if a majority decides they want to join the US, Ottawa and the rest of provinces would need to negotiate on what that looks like. And that would give us, one last chance to convince Alberta. Maybe we give them a pipeline to Eastern Canada or the Arctic. Maybe we agree not to cap their oil sands production. Maybe we even give them their own pension plan, although I don't know if I like that one. And maybe we stop forcing them to pay quite so much equalization payments to the East, and then they would be convinced that they still love us and want to stay. But maybe they come to a deal and do secede. So, I asked Joanna if we could talk about this on the podcast. She said, yes, you can, as long as you make clear that this is probably not very likely to happen. And so it's a theoretical exercise. But Christine, you've got a lot of Albertan friends. They're talking about this. How serious do you think they are about ditching us for America?
Yeah, I love Alberta. I go to Alberta a couple times a year. It's such a beautiful and amazing place. But I do not think that this is going to happen. The people from Alberta who are kind of endorsing this idea, none of my friends want this in Alberta. And the people that I see endorsing this idea, I don't know if they're real people. Like, I see it on Twitter, but I don't, and in YouTube comments, I don't know if they're real people. But what I would say is that the idea of the United States acquiring Alberta is much more likely than the United States acquiring the rest of Canada. Like, I do not think that Donald Trump is serious when he says Canada would be the 51st state. Like, he does not want a bunch of Democrat voters joining the United States. If Canada were to, again, this is all theoretical, and I obviously don't want this to happen, but if Canada was to be acquired by the United States, it would not be as a state. I think we would be treated like a territory without the same voting rights to vote for president and things like that. So I don't think we would be treated the way New York State is treated. The exception might be Alberta under this president, but still, I don't think that is likely to happen. At least with Alberta, you would get kind of a route to the north somehow, sort of. So, I mean, there's that. But there's no way that Donald Trump wants a bunch of maritime and Quebec voters joining the United States. And I don't think Americans want that either. I don't think Albertans want this either. One thing I'll say that was interesting, that I had a conversation earlier this week. I was at Massey College moderating a panel about what's next for Canada and the United States. And one of my questions was about Danielle Smith and how she's kind of negotiating on her own with, or trying to, or maybe you don't even want to call it negotiating, whatever she's doing, and trying to get these carve outs from any tariffs for Alberta oil. And we were talking about, the reasons for doing that, how that is perceived in Alberta. And one of the panelists, I was interviewing Jamie Watt said that she's doing this because, her constituency in Alberta demands that she do that. She does not even have an option. That is something that she must do in order to stay as premier. And then I was also interviewing the chair of the Broadband Institute. I think his name is Brian Platt. And he said, no, people in Alberta don't like this. They think that this is a bad idea and that it's going to hurt Alberta. And I do not agree with that at all. The people that I know from Alberta, they do not want to be part of the United States, but they definitely do not trust the Trudeau government and the East to negotiate any sort of deal that would not throw Alberta completely under the bus. And these people might not even be, hardcore Danielle Smith supporters, but they agree that Alberta needs to stand up for its own interests in this negotiating, that they don't trust the federal government, they don't trust the East, and they want a deal for Alberta oil that protects Albertans. So at least on that front, Alberta is doing its own thing, and I think that it is at the demand of the Alberta voters. But if you're listening to this, you're from Alberta. Look, we're not from Alberta, even though we are headquartered in Alberta. Josh and I both live in Toronto. If you're listening to this, you have a different perspective. Leave a comment if you're watching this on YouTube. Let me know what you think either of the secession proposals that we don't really think are realistic, but definitely let us know what you think of Danielle Smith's negotiating independently or attempting to negotiate independently. That's all I'll say about that. I don't think it's a real likelihood that there's going to be any type of recession from the union by Alberta. Let me talk about what I want to talk about today, which is myself. I want to talk about our cases that we're currently doing at the CCF, because we have a lot going on right now. And I thought that it's coming up to the end of January. It's a good time to remind our listeners where things stand with our own cases, with what we're working on, because, not to be too braggadocious, but our cases literally are news headlines. We litigate some of the most novel and interesting cases in Canadian law. So I want to give you an update on what's happening. And the biggest one that we have is the Emergencies Act hearing, which is going to be taking place in 2 weeks. We will be appearing at the Federal Court of Appeal in front of a 3-judge panel, arguing to uphold that massive victory that we had at the lower court when Justice Mosley found that Trudeau's use of the Emergencies Act was illegal and unconstitutional. That was the legal challenge to the Emergency Act response to the Freedom Convoy. The federal court found that there was no national emergency, that there was no threat to the security of Canada. And, this is a law that exists to deal with wars, terrorist attacks, massive natural disasters, not Canadians protesting on the steps of Parliament, even if they are especially noisy and stubborn. That just isn't what the law was created to do. And when it was used, when it was invoked, Trudeau was able to create new criminal law by executive order, essentially. He used that power to freeze bank accounts and to ban protests across the country, not just in Ottawa. And the lower court rightly found that this went too far. It violated those precious rights of freedom of expression and freedom from an unreasonable search that are protected in our Constitution, which is the supreme law of our country. And it's a really vital decision to protect. It sets a precedent that will stop governments from abusing the Emergencies Act in the future. But of course, the Trudeau government is trying to set back our civil liberties by having that decision overturned. And we filed our factum a little while ago. It's available on our website if you want to go and read it, theccf.ca. And actually the hearing, which begins on February 4th, will be live streamed. I just found this out. I have the link. If you want to watch the live stream of the hearing, I will be sending that link out to all of our email subscribers next week, as well as with a reminder on February 3rd about the hearing the next day. So if you are signed up for our freedom updates, you will get that link to live stream. If you are not signed up, you can sign up to watch that at the ccf.ca/freedom updates. And I will also be doing a daily recap on YouTube. So if you miss the hearing, if you watch our YouTube channel, you'll be able to watch me summarize what happened during the hearing. It's supposed to be a 2-day hearing. The government is trying to make it shorter, but we'll see. It's supposed to be on the 4th and on the 5th. So the next update is about what's happening today. We're actually in court today in Calgary for that case I've talked about, challenging a Calgary bylaw that bans protests near libraries and community centers. And that bylaw was enacted by the city in response to protesters who had disrupted a program at the library where drag queens would read stories to kids. And the program was called Reading with Royalty. And look, you can think whatever you want about that program. I mean, personally, I would not take my child to that program, but maybe other people are into that, and that's their choice. They can do what they want. And obviously there are people who are not into it and they wanted to protest this program. And to the extent that those protests actually disrupted the event, which, some of them did, they can be removed. Like, you can have security remove someone who's disrupting an event, obviously. But if the protesters want to stand outside the library or the community center with signs, that is a constitutionally protected right. And the city of Calgary banned protests like this on the basis of the subject matter. The bylaw actually lists the topics about which you can protest and which you can't. And that is not something that the government gets to decide. They don't decide what you're allowed to protest and what you're not allowed to protest. And the bylaw was actually even more kind of crazy than this, that just banning subject matter. When you look at the map of where it applies, so it created these like bubbles around the entrances of libraries, and the areas where that bubble applies actually ban protests on like private property down the street. Like it would ban you from putting up a sign in your front yard or even in your backyard or in a back alley. It applied to like the highways or near these facilities. All of this just doesn't make any sense. And so we announced our legal challenge to this basically within days of the bylaw being passed in March of 2023. It's obviously now January 2025. Our court system is incredibly backed up. So we didn't even get a hearing date until, a month from now, at the end of February of this year. And the totally insane thing that we're in court today about is that, this hearing is set to take place in about a month. And the city just now has asked for an adjournment. And they've had 2 years to get ready. And now all of a sudden they want this adjourned. And the reason they say is because there was actually one individual who, there might be more, but there's definitely this one individual who was charged under the bylaw, which by the way carries a 1-year sentence for jail. And this was someone who was, engaging in one of these forbidden protests. And it involved a man, his last name's Heather, Mr. Heather. Mr. Heather's case is a provincial court case. So the issue is they want our case adjourned in favor of an appeal that is not yet perfected in Mr. Heather's case. And Mr. Heather's case, as I said, it's a provincial court case, which means it won't create a broad precedent. If the law in his case is, if it can be found to be of no force and effect, but only with respect to him, it has no authority in other cases. In contrast, ours is a judicial review that could actually have the law, struck down. Put bluntly, our judicial review is fully perfected. We filed our factum, and it's set to proceed in about a month. The Heather matter is not. Mr. Heather waited too long to file his appeal. He didn't coordinate with any of the relevant parties. We haven't spoken to him about this, yet the city somehow wants our cases combined or adjourned in favor of his case. And the city hasn't explained why they need this adjournment. They're basically just trying to delay the proceedings. So today we're in court fighting the attempt by the city to wiggle out of that hearing that in the case we brought almost 2 years ago. And look, I'm hopeful that we will win on this adjournment issue and the case will proceed on February 25th as it's supposed to. Now, my other updates are on 2 Supreme Court hearings that are coming up. We just filed our materials on Monday in a Supreme Court intervention in a case called R and Singer. And that's a case that we've talked about on this podcast before. It's about the scope of the police search powers, and in particular, the what is called the implied license to knock. So police can approach your door without a warrant for the purposes of communicating on you, like coming up to your door, knocking on your door and talking to you. But the question in Singer is, can they approach your vehicle parked on your driveway, peer into the windows of the vehicle, and then open the door of the vehicle? Is that part of the implied license? And we say no, the implied license does not go so far that allows the police to search a vehicle on your property without a warrant. If the police want to do something like that, they can go and get a warrant. We also have another hearing coming up in a Supreme Court intervention in a case called R and Taylor. This is the first COVID era case that the Supreme Court is hearing, and it's about whether or not there's a constitutional right to move and travel around within Canada. So in Taylor, it involved a woman named Kim Taylor. She was from Nova Scotia. She wanted to go to Newfoundland for her mother's funeral, and public health restrictions at the time prevented her from doing that. And the Newfoundland government has said that in Ms. Taylor's challenge to that law, they said there isn't a constitutional right to travel within Canada. And I think, and we think at the CCF, and we'll be arguing in court, that that's inconsistent with the text of the charter itself and with the Constitution when you read it as a whole. So we're intervening in that case. And we're also applying to intervene in a third Supreme Court case this year. It's a case called Quebec and Canada. And we don't have leave in this case yet. We are working on our materials like as I speak. Our lawyers are working on those leave materials. That's a case about a woman named Bijou Kenyinda, and she entered Canada illegally at Roxham Road and applied for asylum. And before her asylum claim was processed, she wanted to access Quebec subsidized daycare for her 3 small children. And Quebec said she was ineligible under its rules for who can access that program. And she argued that that was discriminatory under Section 15 of the Charter. So we want to make a contribution to the development of the Section 15 case law and push back on what we see as a movement towards positive rights. Like you don't have a positive constitutional right to subsidize daycare. We don't have leave yet, so stay tuned. But these are 3 Supreme Court interventions this year, which is pretty good. Honestly, that's good. Especially when you compare it to this kind of drought that we've seen of Supreme Court granting leave in cases. Like they're not hearing very many cases, honestly, and we have leave in 3 of them that they are hearing. So we have leave in 2, and we're hoping to have leave in a 3rd all this year. So that's pretty good for a small and feisty little organization like ours. We do have even more than this going on, but I'm going to stop there because I could go on forever about all the stuff that we're doing. I will just mention the one case that has been consuming Josh's life, and that is a PEI case involving a municipal councillor that is set to proceed to a hearing next month that Josh is going to be in PEI arguing. So Josh, tell us about that.
Yeah, I was just going to say I had myself on mute. You're saying this is a lot to do in 1 year for a small, feisty organization. It's January 22nd, so like we are just we've got a lot going on right now. There are 3 other cases where we're hoping to get leave to intervene that we're also working on that have been consuming me, and they span right from the extreme east of Canada, Newfoundland and Labrador, all the way to British Columbia. So just an insane amount going on. Yeah, so this PEI case, it really has been consuming like a huge amount of my time, and that's just because it's going to be the first judicial review that I'll actually be arguing myself, and I'll be there with the assistance of our excellent local lawyer who's named Brandon Forbes. And this, of course, is the Robertson case that I've mentioned many times on this podcast before, a case we took on almost a year ago at this point. And this is a freedom of expression case about whether or not a politician, in this case, a councillor in Murray Harbor, Prince Edward Island, has a constitutional right to express himself on a sign on his private property where the message has nothing to do with his official functions or decision making for the municipality. And obviously we think that it does. The sign was undoubtedly controversial. There's lots of evidence in the record about people who agreed with his message and people who disagreed with his message. His message, again, Christine, you'll recall, is he wrote on a sign that's on his property, "Mass grave hoax, redeem Sir John A's integrity." Reconciliation, redeem Sir John A's integrity. And, you know, this obviously offended people on one side of the issue, but other people were saying, no, he's just, you know, making a comment about claims in the media that were wrong, or at least not supported by evidence about a mass grave being found at a school in CanLII, BC. So yeah, I've been getting ready to argue this, and it's so complicated, and there's so much to say because the investigation that forms the reasons that council relied on was just so botched. Like there are just so many things in it that we can attack and point to and say, you know, this is not a reasonable decision. It doesn't meet the requirements when a constitutional right is at issue. And so, yeah, my purpose has been trying to get all of these things into a short enough amount of time because The court's given us a relatively generous amount of time, but there's just never enough time to say everything you want to say. And there's so many different things that the judge could ask us about that we need to be prepared to respond to. So, yeah, that's been consuming a lot of my days, and I'm looking forward to it. I just learned that in Prince Edward Island, you address the judges as my lord and my lady still, which is very old-fashioned but kind of cool. And I'm just hoping I don't get that wrong, that I remember to use the correct term if I'm addressing the judge. So looking forward to that. And yeah, okay, so Christine, before we move on to our bad legal takes, let's just take a little break. All right, so my bad legal take goes to Antifa. Sorry, the Canadian Anti-Hate Network, for tweeting that Meta's new policy that allows users to deny the existence of gay and transgender persons seems to be incompatible with Canadian law, which has found that those kinds of statements are hate speech. Now, when people, including me, pointed out that no, this is not under Canadian law hate speech, they shared a quote from a BC Human Rights Tribunal decision that found that a flyer, quote, denying the reality of transgender people in the context of the pernicious myth that transgender people do not exist, can expose a person to hate speech. Okay, so to be fair to Con, it's notoriously difficult to define what hate speech is in Canada. Everyone struggles with the concept. But I can say pretty definitively that no, Meta's new policy, which basically says that you can, make fun of anyone, including LGBTQ people. You can even call people mentally ill or say that men can't be women and vice versa, without, getting your speech removed, is not hate speech. Hate speech is, according to the Supreme Court, only the most extreme manifestations of the emotions described by the words detestation and vilification. And the court has since said in the Ward case that you can't ban speech based on its subjective offensiveness. And the speech that Con is talking about can't be limited without violating freedom of speech in a way that's not demonstrably justified in a free and democratic society. So in Ward, and this of course is the case we've talked about before that we intervened in with the comedian Mike Ward, who was fined for making what many people consider offensive jokes about a disabled Quebec boy. In that case, the Supreme Court rejected the Quebec court's view that offensive speech can be limited to protect human dignity. And what the Supreme Court said is that the applicable test is this: it can't be focused on either the repugnant or offensive nature of the expression or the emotional harm caused to the person, because otherwise that would amount to censoring expression because of its content or its impact on a person rather than on its discriminatory effects. And what the court said was that the test for resolving a conflict between the right to freedom of expression and the right to safeguard dignity requires that it be determined first whether a reasonable person aware of the relevant context and circumstances would view the expression targeting an individual or group as, and this is the important part, inciting others to vilify them or detest their humanity on the basis of a prohibited ground of discrimination. And second, it must also be shown that a reasonable person would view the expression considered in context as likely to lead to discriminatory treatment of the person targeted. So as a result of this test, which is a bit unwieldy, obviously, but we can still figure out, only expression that, considered in the context, is likely to jeopardize the social acceptance of the group is discriminatory. And the analysis is not going to be focused on the content of the expression, but only on its potential to create effects on this third-party group. So, simply saying that someone is I don't think men can be women, or that transgender people don't really exist, or even something like gay people are mentally ill, which obviously I don't agree with, still isn't hate speech. It might be offensive, but it's not hate speech because you're not inciting others to vilify or detest the humanity of that group. That is like an extreme thing to do that wouldn't be done in the vast majority of cases where you're saying these types of lawful or but awful or subjectively offensive things, right? So Meta's policy doesn't encourage hate speech, and the vast majority of the speech that Con is talking about is not hate speech. So don't quit your day job, Con, fighting fascists in the streets. Let's hear your BLT.
I kind of think Canadian Anti-Hate Network is one of these lifetime achievement bad legal take people or organizations. Like they're just perpetually on our lists. So my bad legal take this week goes to the Court Challenges program. And I've talked about this before. I don't know if I've given them a bad legal take, but it's because there's some new reporting from Blacklocks, who I love, about one of the cases that got funding through the Court Challenges program. And to be clear, my bad legal take is that this program exists at all. This is a program that gives taxpayer money to activist groups suing the government or involved in public interest litigation. The mandate of this program is to support test cases of national significance seeking to affirm and clarify certain constitutional and quasi-constitutional official language rights and human rights cases in Canada. And the cases that get funding are not disclosed publicly, at least while they're in litigation. And the cases that get funding, taxpayer funding, that you and I are all paying for, they are all hand selected by a board that is appointed by the Minister of Heritage. So you can tell the ideological tilt that approved cases will have. For example, we in a million years, even though we do a lot of public interest litigation on test cases about rights, we would never get approved for funding. Not that we would ask for it, but there's no way we would ever, like our Emergencies Act case, like such an important civil liberties case, we would never have had that case approved, even if we had applied for funding. So the program since 2017 has spent $24.9 million in taxpayer funding. And there's a huge transparency issue because we don't know who gets funding while these cases are underway. And now Blacklocks, I love them, has reported that the government actually gave money to a pro-government intervener in the carbon tax case from 2021. The federal government Court Challenges program paid interveners to take the federal government's side in this Supreme Court challenge to the carbon tax. And Blacklocks actually asked the Court Challenges program about it, but they would not discuss these subsidies that these advocacy groups were given to argue in favor of the carbon tax. Now, I think it's one thing, and it's a bad thing, to give money to litigants who are suing the government. It's another to give money to litigants who are then supporting the government. They're just padding their own interveners with our money as we sue the government. Like, that is disgusting. And it's not even the first time it happened. It happened in a freedom of expression case involving Stephen Harper, this sort of political advertising case when I think he was with the National Citizens Coalition. There was a pro-government intervener who got money from this program back then as well. So this program needs to end. If we have a new government, if we have a conservative government in the next election, this program needs to be at the top of the chopping block because it's disgusting. That's it for me. Josh?
Yeah, I couldn't agree more. I actually testified in Parliament about this, and I said we need the Court Challenges program has got to go. As usual, we hope you'll rate us, review us, and subscribe, and you can support our work by visiting our YouTube channel, by following us on X, by visiting our website where you can sign up for our Freedom Update newsletter. If you want that link Christine mentioned to watch our Emergencies Act case, I think signing up for the newsletter is a good call. The CCF is a nonpartisan legal charity funded by your donations, so please do donate on our website if you can. Thanks for listening.